Recently, Cafcass reaffirmed their commitment to recognising parental alienation through their Child Impact Assessment Framework. However, the problem is that the Child Impact Assessment Framework is so utterly flawed and unfit for purpose in identifying and managing parental alienation that it doesn't matter how many times Cafcass say they recognise it, they remain inept and incompetent in understanding and responding to it. With a decade of experience within the family court, I'm going to walk you through the nightmare scenario of a father who is being alienated and his nightmare journey through the family court system. The character is called Matthew Groves. He separated from his wife Abigail Groves 3 months ago, and his wife has stopped contact with their child called Daniel, who is 11 years of age. I do recognise, of course, that parental alienation is not specific to any gender, but in this scenario, it is a father seeking contact. All characters are entirely fictional. I am Philip Kedge, the director of the Mackenzie Friend UK Network. I am a retired police chief inspector and the founder of the national campaign #LightNotHate at lightnothate.co.uk, and in all my videos, my views and opinions are entirely my own. Before I start the story, we need to understand why the Cafcass Child Impact Assessment Framework is so fundamentally flawed. Now, Cafcass defined parental alienation as being when a child's resistance or hostility towards one parent is not justified and is the result of psychological manipulation by the other parent. Now, the key here are the words "not justified." You see, Cafcass considers that there are legitimate reasons where the resistance or hostility of a child to contact may be justified, including, for example, domestic abuse, harmful conflict or attachment issues. Cafcass states that if appropriate justified rejection does not appear to be a factor in the assessment of the reason for the child's resistance or refusal, our family court advisors will proceed to assess the other possible reasons for this. Now, this means that they have to eliminate every other factor before they will even consider parental alienation as a possibility. So let's see what happens when we put that irrational and ill-conceived policy into a realistic scenario. Mr. Groves left the matrimonial home 3 months ago. Contact with his son Daniel, who is 11, was ad hoc and sporadic. But one day he received a message from Abigail that Daniel didn't want to see him at this time. Matthew was confused and upset. He understood that the home environment had been difficult over the last year, but never thought that Daniel would not want to see him. However, in trying to do the right thing, he agreed that Daniel may need some space and decided to not push for contact over the next couple of months, in the hope that things settle down. During the next 3 months, Abigail kept on saying that Daniel did not want to see him. He became very concerned. Matthew attended a MIAM in the hope of starting mediation, but Abigail did not respond. Matthew decided that he had no choice but to submit a C-100 application to the family court for an order to see Daniel. 5 weeks later, Kafkas called him for what's known as a safeguarding call and letter. Matthew raised his concern that he believed Daniel was being alienated. Kafkas mentioned his concerns about parental alienation in the safeguarding letter, but that letter seemed more focused on allegations by the mother that she and Daniel had suffered abuse and emotional harm. Kafkas suggested that the court should consider a fact-finding under Directions 12J, which provides the directions that a court must consider where there are allegations of abuse. By the time of the first hearing, which is called the First Hearing Dispute Resolution Appointment, Matthew has not seen Daniel for 5 months. At the hearing, Abigail forcibly stated that Daniel did not want to see Matthew. Kafkas recommended no direct contact until a fact-finding hearing was conducted based on her allegations of domestic abuse. The judge agreed, stating that the court could not force contact at this time and required Abigail to prepare a Scott schedule listing her allegations and for Mr. Groves to make his preliminary responses to the allegations. A date was set to return to court for a directions hearing in 3 months' time. Whilst waiting for the next court date, Daniel turns 12 years of age. Now, at the point of attending the directions hearing, Matthew has not seen Daniel for 8 months. At the hearing, the judge looks at Abigail's Scott schedule, which is the list of her allegations of abuse, and Mr. Groves' initial responses. Abigail has raised 8 allegations, and the judge strikes out 3 of them as holding little relevance. For the remaining 5 allegations, the judge sets a fact-finding hearing for 3 months' time. No interim contact is ordered, as Abigail insists that it is not safe for contact to start prior to the fact-finding, and that Daniel is still refusing to see Matthew. 3 months later, the fact-finding takes place. It has now been 11 months since Matthew has seen Daniel. At the conclusion of the fact-finding, the judge finds that Mr. Groves had, at times, shown some inappropriate parenting in the way that he had chastised Daniel when he was younger. It was also found that during the 12-year marriage, he had, on 3 previous occasions, shouted and sworn at Abigail in the presence of Daniel. But there were no findings of coercive control or physical abuse. Matthew asked for urgent contact to be resumed. He raises his concerns of parental alienation and asks for a guardian to be appointed. The judge declines the notion of a guardian as not meeting the requirements, and asked Kafkas for a Section 7 report for recommendations based on the findings of fact. No interim contact is ordered. Abigail argues that there should be no contact until the Section 7 report is completed, and in any event, Daniel is refusing, and Kafkas needs to seek his wishes and feelings. A new court date is set for 3 months' time. It takes 10 weeks to complete the Section 7 report, and they return to court. Matthew has now not seen Daniel for 14 months. Kafkas has spoken to Daniel and reports that he shows significant hostility towards his father. Kafkas suggests that the narrow findings of fact does not explain Daniel's reaction to contact. With regard to the Child Impact Assessment Framework, they have dismissed justifiable factors such as abuse or a harmful relationship. They recommend that the court considers a guardian, which is of course what Matthew asked for 3 months earlier. The judge agrees and sets a court date in 2 months' time for the appointment of the guardian. It is now 16 months since Matthew has had contact with Daniel, and at the next hearing a guardian is appointed. The guardian recommends that a psychologist conducts a family assessment to determine the issues as to why Daniel is resisting contact, and that this can be paid for through the guardian and Daniel's legal aid. The judge agrees to an assessment and orders a psychologist report and to resume a directions hearing in 3 months' time. During those 3 months, both parents and Daniel cooperate with the family assessment by the psychologist. And during this period, Daniel has now turned 13 years of age. The psychologist's report is completed and they return to court for the next directions hearing. Matthew has not seen Daniel for 19 months. The psychologist concludes that there is evidence of moderate parental alienation by the mother, and the father feels elated. At last, someone who has finally listened. However, that elation doesn't last long, as Abigail refutes the findings and states that it is only an opinion that she rejects. The judge explains that although there is an expert opinion, there's been no fact-finding on the question of parental alienation. The judge makes a decision that any findings on parental alienation can form part of a final hearing. This matter has been in court for over 1.5 years and needs to be concluded. A 3-day final hearing date is set in 3 months' time. The psychologist is to attend to give evidence, and both parties are to submit their final statements. The 3-day final hearing arrives. It has now been 22 months since Matthew has seen Daniel. Daniel has submitted a letter to the judge stating that he does not want to see his dad and for the court to respect his wishes. During the final hearing, both parties, the guardian and the psychologist, attend. It is a 3-day hearing of cross-examinations and final submissions. On the morning of the 3rd day, the judgment is given. The court finds that there has been moderate parental alienation by the mother over a protracted period of time, and in the absence of any other credible factors, that this is the cause of the ongoing conflict between Daniel and Matthew. However, the judge states those words that no one wants to hear. We are where we are, and determines that the wishes of Daniel, as expressed to the psychologist and to Cafcass and within his letter, does carry weight given his age, that the court simply cannot force a 13-year-old boy to engage in contact that he does not want, even if his thoughts and beliefs have been manipulated. After 22 months, the judgment is not to make an order for direct contact, but the father is able to send a Christmas card, a birthday card, and to write a letter every 3 months. The judge expresses sympathy and hopes that in time Daniel will indeed understand that he needs his father in his life and reaches out to him. The mother sits there grinning. Everything has worked out just fine. The case is over. There will be many of you who are watching this video who have experienced this scenario or are right now going through it. My heart and thoughts go out to you. What can I say? I need to let this video speak for itself. The public should be outraged. People need a voice. The family court must be forced to change once and for all. Let's finish by returning to the problem, the deeply flawed and incompetent policy known as the CAFCASS Child Impact Assessment Framework. The framework that claims to recognise parental alienation, but only after every other possible reason for a child rejecting contact has been investigated and dismissed. A framework that absolutely prioritises allegations of domestic abuse, but fails to consider that parental alienation is domestic abuse. Serious domestic abuse that destroys the lives of children. And if that wasn't enough of a problem, we also have the court directions of 12J that again fails to recognise parental alienation as abuse, resulting in the alienated parent's voice never being properly heard. The Domestic Abuse Bill must include parental alienation as domestic abuse. Otherwise, the courts will be no further forward. As things stand, by the time anyone opens their eyes to even the possibility of alienation, the damage has often been irreversibly done, and the alienation set in. Mr. Groves never stood a chance from the outset. If you would like to talk to an independent Mackenzie friend from the Mackenzie Friends UK network about parental alienation or any aspect of your family court case for a free 1-hour consultation, then please visit www.lightnothate.co.uk, and please don't forget to subscribe to my YouTube channel.